don't understand these people living with HIV people's memorandum. Yes, I don't understand how.
And do you know the 18%?
Meeting call to order. So we are starting with a clause by clause consideration from clause 1 to clause 18. Secretariat,
Please. All right.
who's available to read from Secretariat? Okay, that's fine. So please.
A bill entitled Human Sexual Rights and Family Values Act 2025, an act to provide for human sexual rights and family values and related matters, passed by Parliament and assented to by the President. Preliminary provision. Clause 1, application. This act applies to a person, A, who holds out as I, a lesbian, I, a gay, I, a bisexual, IV, a transgender, V, a transsexual, VI, a queer, VII, an ally, VIII, a pansexual or IX, a person of any other sexual orientation or in a sexual relationship that is contrary to the sociocultural relationship between a male and a female. B, who is involved in the promotion of, propagation of, advocacy for, support of funding of LGBTQAP+. C, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is intended to correct a biological abnormality, including intersex, or D, who engages in a sexual activity prohibited under this act. Human sexual rights and family values. Clause 2, duty to promote human sexual rights and family values. 1, a citizen shall promote and protect the human sexual rights and family values specified in Section 18 of this Act. 2, subject to Article 39 of the Constitution, the following persons or institutions shall, within the control of the persons or institutions, promote and protect, through formal and informal education, human sexual rights and family values. A parent. B, a guardian. C, a religious instructor, a teacher, or any other educational instructor. D, a traditional institution, a church, a mosque, or any other religious organization. E, an organ of state and a state institution. And F, the media and the creative arts industry. 3, a person or institution referred to in subsection 2 shall A, ensure that the human sexual rights and family values are preserved and integrated into the fabric of national life through formal and informal education. B, make conscious effort to introduce the human sexual rights and family values dimensions to relevant aspects of national planning. And C, ensure that the human sexual rights and family values are adapted and developed as an integral part of the growing needs of society. LGBTQAP+ and related activities. Clause 3, prohibition of LGBTQAP+ and related activities. 1, a person shall not A, engage in a I, sexual intercourse with a person of the same sex. II, sexual intercourse with an animal, or III, pansexual activity. B, marry or purport to marry a person who is of the same sex as that person. C, knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except in the case of a person who has undergone a surgical procedure to correct a biological abnormality, including intersex. D, marry or purport to marry an animal or object. E, hold out as I, a lesbian, II, a gay, III, a bisexual, IV, a transgender, V, a transsexual, VI, a queer, VII, a pansexual, VIII, an ally, IX, a non-binary, or X, any other sexual or gender identity that is contrary to the binary categories of male and female. F, provide or participate in the provision of I, a surgical procedure for sex or gender reassignment, or II, any other procedure that is intended to create a sexual category other than the sexual category of a person determined at birth, except in the case of correcting a biological abnormality, including intersex, or G, undergo a surgical procedure for sex or gender reassignment, or II, any other procedure that is intended to create a sexual category other than the sexual category of the person determined at birth, except in the case of correcting a biological abnormality, including intersex. 2, a person who contravenes paragraph A, B, C, D, E, F, or G of subsection 1 commits an offense and is liable on summary conviction to a fine of not less than 750 penalty units and not more than 5,000 penalty units, or to a term of imprisonment of not less than 2 months and not more than 3 years, or both. 3, for purposes of this section, sexual intercourse occurs where a person A, penetrate the anus or mouth of a person of the same sex with the penis of that person or other device. B, penetrate or stimulate the vagina or anus of a person of the same sex by use of any object or device. C, penetrate the anus, mouth, vagina, or other bodily opening of an animal by use of the penis of the person or any other object or device. Or D, allows penetration of the anus, mouth, vagina, or other bodily opening of that person by an animal for sexual gratification. 4, this section shall read together with subsection 2 of section 104 of the Criminal Offences Act 1960, Act 29. Clause 4, procuration. A person shall not by threat, obstruction, deterrence, improper or corrupt means, molestation, intimidation or inducement, false pretense or false representation, procure another person to engage in a sexual act prohibited under this act. 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of not less than 25 penalty units and not more than 500 penalty units, or a term of imprisonment of not less than 3 months and not more than 3 years, or both. Clause 5, detention with intent to commit prohibited sexual activity. 1, a person shall not detain another person with intent to cause that other person to engage in a sexual activity prohibited under this act. 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 months and not more than 3 years. Clause 6, keeping a brothel for a prohibited sexual activity. 1, a person shall not keep a movable asset, a room, a house, or any other asset for purposes of a sexual activity prohibited under this act. 2, a person who A, owns or occupies, B, manages or controls, or C, acts or assists in the management or control of a movable asset, room, house, or any other asset shall not induce or allow another person to be in or on the movable asset, room, house, or any other asset for the purpose of engaging in or promoting a sexual activity prohibited under this act. 3. A person who contravenes subsection 1 or 2 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 years and not more than 6 years. Clause 7. Prohibition of gross indecency. 1. A person shall not publicly and willfully undertake a grossly indecent act. 2. A person who contravenes subsection 1 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 6 months and not more than 1 year. 3. For purposes of this section, grossly indecent act means A. Public show of romantic relations between or among persons of the same sex. B. Public show of romantic relations between or among persons where one or more of the persons have undergone gender or sex reassignment. Or C. Cross-dressing to portray that the person is of a gender different from the gender determined at birth with intent to engage in an act prohibited under this act. Clause 8. Void marriage. 1. A marriage entered into by the following persons is void. A. Persons of the same sex. B. A person who has undergone gender or sex reassignment. Or C. A person who has undergone any other procedure that is intended to create a sexual category other than the sexual category of the person determined at birth, except in the case of correcting a biological abnormality, including intersex. 2. A certificate issued by a foreign authority pursuant to a marriage under subsection 1 is unenforceable in Ghana. 3. A person shall not A. Administer, witness, abet, solemnize, or aid in the solemnization of a marriage under subsection 1. Or B. Issue or aid or abet in procuring a certificate in respect of a marriage under subsection 1. 4. A person who contravenes paragraph A or B of subsection 3 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 1 year and not more than 3 years. LGBTQAP+ propaganda, advocacy, support, and other promotional activities. Clause 9. Prohibition of propaganda of promotion of and advocacy for activities prohibited under this act. 1. Subject to the Constitution, a person shall not produce, procure, market, broadcast, disseminate, publish, or distribute through A medium, technological platform, technological account, or any other means, or B, a film, the internet service, an electronic device, or any other device capable of electronic storage or transmission, a material for purposes of promoting an act prohibited under this act. 2. A person shall not A. Promote or support an act prohibited under this act. B. Engage in, participate in, promote or support an act aimed at changing public opinion towards an act prohibited under this act. Or C. Offer premises or any other movable or immovable asset, or provide any form of assistance for purposes of promoting an act prohibited under this act. 3. A person who contravenes subsection 1 of paragraph A, B, or C of subsection 2 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 5 years and not more than 10 years. 4. Where a person is convicted under subsection 3, the owner of the medium, technological platform, or technological account on which the material or information is produced, procured, marketed, broadcast, disseminated, published, or distributed is deemed to have committed the offense unless it is proved that the owner A. did not consent to or connive at the commission of the offense, and B. exercise the degree of reasonable diligence as necessary in the circumstances to have been exercised to prevent the commission of the offense. 5. Where A body corporate is convicted under subsection 3 of this section, subsection 2, 3, 4, 5, and 6 of section 25 of the Interpretation Act 2009, Act 792 shall apply. Or B, an unincorporated body of persons is convicted under subsection 3 of this section, the principal officers of the body of persons shall be deemed to have also committed the offense unless it is proved that a principal officer, I, did not consent to or connive at the commission of the offense, and I exercise the degree of reasonable diligence as is necessary in the circumstances to have been exercised to prevent the commission of the offense. Clause 10. Prohibition of propaganda of promotion of and advocacy for activities directed at a child. 1. Subject to the Constitution, a person shall not produce, procure, market, broadcast, disseminate, publish, or distribute, A, through a medium, technological platform, technological account, or any other means, or B, through a film, the internet service, or electronic device or any other device capable of electronic storage or transmission, a material or information directed at a child, whether directly or indirectly, with the intent to C, evoke the interest of the child in an act prohibited under this act, or D, teach the child to explore any gender or sex other than the binary category of male or female. 2, a person who contravenes paragraph A, B, C, or D commits an offense and is liable on summary conviction to a term of imprisonment of not less than 6 years and not more than 10 years. 3, where a person is convicted under subsection 2, the owner of the medium, technological platform, or technological account, or any other means on which the material or information is produced, procured, marketed, broadcast, disseminated, published, or distributed, is deemed to have committed the offense unless it is proved that the owner A did not consent or connive at the commission of the offense, and B, exercise the degree of reasonable diligence as necessary in the circumstances to have been exercised to prevent the commission of the offense. 4, where A, body corporate is convicted under subsection 2 of this section, subsection 2, 3, 4, 5, and 6 of section 25 of the Interpretation Act 2009, Act 792 shall apply, or B, an unincorporated body of persons is convicted under subsection 2 of this section, the principal officers of the body of persons shall be deemed to have committed the offense unless it is proved that a principal officer, I, did not consent to or connive at the commission of the offense, and I exercise the degree of reasonable diligence as is necessary in the circumstances to have been exercised to prevent the commission of the offense. 5, for the purposes of section 9 and this section, electronic device means a component that is used for controlling the flow of electronic currents for the purpose of information processing and system control. Internet service means services provided to the public whose provision consists of subscriber interaction with the internet or the transmission of information to or over the internet. Medium includes radio, newspaper, and television. Owner means the legal owner or operator of the medium, technological platform or technological account, or any other means, and where the media, technological platform, technological account, or any other means is owned by more than one person, includes every joint owner. Technological account includes Facebook account, X account, Instagram account, and any other social media account. And technological platform includes website, Facebook, X, Instagram, and other social media applications and sites. Clause 11, prohibition of funding, sponsorship, or promotion of prohibited acts. 1, a person shall not fund, sponsor, or promote an act prohibited under this act. 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 years and not more than 5 years. 3, where A, a body corporate is convicted under subsection 2, subsections 2, 3, 4, 5, and 6 of section 25 of the Interpretation Act 2009, Act 792 shall apply. Or B, an unincorporated body of persons is convicted under subsection 2, the principal officers of the body of persons shall be deemed to have also committed the offense unless it is proved that a principal officer, I, did not consent to or connive at the commission of the offense, and I, exercise the degree of reasonable diligence as is necessary in the circumstances to have been exercised to prevent the commission of the offense. Clause 12, disbandment of LGBTQAP+ group, society, association, club, or organization. Any group, society, association, club, or organization in existence before the coming into force of this act, whose purpose, whether partly or fully, overtly or covertly, is to promote, facilitate, support, or sustain in any way an act prohibited under this act is disbanded. Clause 13, prohibition of LGBTQAP group, society, association, club, or organization. 1. A person shall not directly or indirectly A. Form, organize, facilitate, operate, or register. B. Promote the formation, organization, operation, or registration of, or C. Participate in an activity to support or sustain a group, society, association, club, organization, whose purpose, whether partly or fully, overtly or covertly, is to promote, facilitate, support, or sustain an act prohibited under this act. 2. A person who contravenes subsection 1 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 years and not more than 5 years. Protection and support for children. Clause 14, prohibition of adoption order for LGBTQAP+ persons. The court shall not grant an application for an adoption order, whether inter-country adoption or otherwise, if the applicant is A. a lesbian, B. a gay, C. a bisexual, D. a transgender, E. a transsexual, F. a queer, G. an ally, H. a pansexual, or I. a person of any other sexual orientation or in a sexual relationship that is contrary to the socio-cultural relationship between a male and a female. Clause 15, prohibition of grant of fosterage for LGBTQAP+ persons. The Department of Social Welfare shall not grant an application for fosterage where the person is A. a lesbian, B. a gay, C. a bisexual, D. a transgender, E. a transsexual, F. a queer, G. an ally, H. a pansexual, or I. a non-binary. Duty to report. Clause 16, duty to report and prohibition of extrajudicial treatment. 1. A person who has knowledge that an offense is committed under this act shall report the commission of the offense to a police officer or, in the absence of a police officer, to a relevant authority of the community in which the offense is committed. 2. A relevant authority to whom a report is made under subsection 1 shall, within 3 days of the report, ensure that the report is made at the nearest police station. 3. A person shall not verbally or physically abuse, assault, or harass a person, A. accused of an offense under this act, or B. suffering from any gender or sexual identity challenge, including LGBTQAP+, or any other variant of a sexual identity challenge. 4. A person who contravenes subsection 3 commits an offense and is liable on summary conviction to a term of imprisonment of not less than 3 months and not more than 3 years. 5. Section 84 and 87 of the Criminal Offences Act 1960, Act 29, apply to this section. 6. Despite subsection 3, the use of graphic description of the behavioral pattern of a person engaged in an activity prohibited under this act, A. for the purposes of education or instruction, or B. in response to any form of advocacy or activism, does not constitute abuse, assault, or harassment. Miscellaneous provisions. Clause 17, regulations. The minister may, in consultation with the ministers responsible for gender, children, and social protection and health, by legislative instruments, make regulations to A. regulate an approved service provider, and B. provide for I. the support of victims of sexual activities prohibited under this act, II. assistance for intersex persons, and III. the effective and efficient implementation of this act. Clause 18, interpretation.
You may.
Skip the interpretation.
Have you dismissed yourself? But there's 19.
So just complete.
You may want to just do the 19. Consequential amendments. 19.
Clause 19, consequential amendment. The Extradition Act 1960, Act 22, is amended in the first schedule by the addition of the following after the paragraph for cybercrime and cyber offenses. LGBTQAP plus offenses, an offense under the Human Sexual Rights and Family Values Act 2025.
Thank you. And all members, Human Sexual Rights and Family Values Bill 2025 under consideration. We will do clause by clause. I start with clause 1. If you have an issue with clause 1, you raise your hand. I give you the opportunity to so we'll consider honorable members first if you have an issue with clause 1, and then we go to the general public as we look. So clause 1. Yes, Honorable Samjoy.
Chairman, I would want to raise an issue that has come to my attention, and this has to do with the term of art. During the break, in fact, before the break, one of our Queen Mothers raised an issue about intersex, and so I did engagement with the CSO called Keywatch Ghana and Intersex Ghana as well, to have a conversation around what the intent was. Chairman, when this bill was first introduced in August 2021, intersex was one of the categories that were criminalized. During our public hearings, presentations were made by civil society organizations and medical doctors that indicated that the intersex community did not see themselves as part of the LGBTQ group, and that the intersex community are completely distinct because in their case, theirs are situations of biological effect and not a personal decision as you see in the other categories. And so we did subsequent amendments to use and introduce an exception clause everywhere criminalization was done or a listing was done to accept the intersex community, just so that we have omnibus provisions that, for example, if you read clause 1A IX, yes, even before I will go there, 1A IX. After we had listed all the people who the act applies to, we say a person of any other sexual orientation or in a relationship that is contrary to the socio-cultural relationship between a male and female. Because of the prospective nature of the legislation, we knew that we could not have exhaustively listed all the categories, so we did that omnibus provision. But the fear there then became that tomorrow, after this bill becomes law, a judge in interpreting this omnibus provision may add intersex. And so we then in C brought in an exception, which says that except where the procedure is intended to correct a biological abnormality, including intersex. Now, a further issue has been raised that there is a societal stigma around intersex persons. And if we keep the phraseology in the bill today of biological abnormality, it lends credence to the fact that intersex people have a biological abnormality, which entrenches a certain stigma. I've worked with them and looked at the proposal they have brought. So this is their proposal. And why I want us to do this in 1C, is that if we do this, then I'll request that, Chairman, it becomes consequential across the entire bill. 1C reads today, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is intended to correct a biological abnormality, including intersex. Chair, they have proposed that we delete except where the procedure is intended to correct a biological abnormality, including intersex, and replace with where the procedure is medically necessary. So
are you doing except where?
No. So it is now. Now it is going to read, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is medically. So you now begin to delete, you delete from intended. So it is medically necessary to address innate variations. Medically necessary to address innate variations in sex characteristics, including intersex. So we replace biological abnormality with innate variations in sex characteristics. Then they continue with additional suggestions, which I have told them we are opposed to, and they've agreed. The complete rendition would have been to continue beyond intersex to say, carried out in accordance with current medical standards and with the full, free, and informed consent of the individual informed, or in the case of a minor, in compliance with law. And we've said that for us, our opposition to that is you then move consent, the right of consent, to a minor, which again becomes a question of legality. And these provisions do not deal with the issue of consent. It deals with accepting intersex persons. So, Chair, it will then read, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except where the procedure is medically necessary to address innate variations in sex characteristics, including intersex. And Chair, if this finds favor with the entire committee, it would then be a consequential amendment across the entire bill. Wherever the exception clause for intersex appears, we will introduce this new phrase to replace just the biological abnormality, so that the bill is not seen to enforce a certain stereotyping and stigma in society. Respectfully submitted, Chair.
Thank you so much. So, I mean, before we even proceed on this, we had some meetings with the Human Rights Committee on this bill, and most of these issues were trashed out, same as we are just reading. They've even been refined. So we are going to post what we have on our general platform, the issues that we had raised. It was clear at that meeting that biological abnormality is a stereotyping word. And so we didn't find any other, apart from intersex. What other biological abnormality would you anticipate? And so, on that note, we decided at that meeting that C will read, and it will have consequential amendments wherever we have biological abnormality. which is a stereotyping word. C will read, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except in the case of intersex. And it ends there. Yes.
Chair, there's no need to litigate this.
No, absolutely.
What the concern was
Yeah.
the use of the phraseology biological abnormality.
So we are
we can
ending
exempt
at
that.
except in the case of intersect, which is what we wanted to take away that biological abnormality.
Chair, we are aligned with that.
Yeah.
I mean, it speaks to the same the spirit of what Keywatch Ghana has also presented.
Absolutely. So, and it doesn't whittle down anything. It still carries the same meaning. And then we rather are taking away that stereotyping word, biological abnormality.
What will be the rendition now?
So the rendition says, C, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other procedure intended to create a sexual category other than the sexual category of a person determined at birth, except in the case of intersex. It ends there, and it carries the same meaning. It takes away the stereotyping and the rest of that, and we will have consequential amendment wherever we find biological abnormality. I think we're good to go on this. Yeah.
Yes, I agree. I agree.
Any on one? We move to two.
Honorable, okay.
Two, please. Yes. Honorable Vice.
Chair. No, 1B. 1B, I think we also we are seeking for further clarification. So if you look at the way it is captured, if I may read, B, who is involved in the promotion of propagation of advocacy for support or funding of LGBTQA+. So what sort of activities are we talking about? It's not clear. Yeah, so if we could add activities of
Prohibited and Basic Act.
yes.
It's a funding.
Yes.
Please go ahead.
Yeah, so funding of activities prohibited under this act.
So that it could be positive or negative. So if we clarify.
What do you have in
I
9?
think we should look at 9.
9.
Let's
9 talks about prohibition of propaganda of, promotion of, and advocacy for activities prohibited under this act.
Chairman, we are just dealing with the scope of application of this bill. We just cannot lift the entire activities that we are seeking to prohibit. That is why there are elaborate provisions under 9, 10, 11 to cover for. So this is just the scope of application, and we leave it at that. When we get to the main body, we can consider that. Thank you.
I think we're good to go. 2, please. Duty to promote human sexual rights and family values. Any comments?
Chairman.
Yes, please.
Chairman, 2 subclause 1. A citizen shall promote and protect the human sexual rights and family values specified in section 18 of this act. Unfortunately, we skipped to section 18, which is rather on interpretations. So there, I see a problem with the cross-referencing.
Yeah, so we'll cross-reference section 18. If you have
Section 18 is not a provision on human sexual rights and family values, but rather on interpretations.
In that, so in the interpretation, we define what human sexual rights are. So in the interpretation, we've defined human sexual rights as a legal term. So once we've done that definition, what 2.1 is referring to is saying that the citizen shall promote and protect the human sexual rights and family values specified as defined, because both human sexual rights and family values have been defined in 18. So that's where the referencing is coming. So the reference is not in error.
Yes, so perhaps what we should be looking at is changing the citizen to a person.
A person shall, a person. So let's be consistent, so that we take out the reference to citizen, and then we have person across. Otherwise, non-citizens.
Came out of because we lifted this out of the Constitution.
Exactly.
If you look at it, it's I think section Article 39 or so.
That's right.
So it was from there we lifted, and so that's why we use the citizen or so. But I'm on all falls with you that we can just use a person.
Every person,
Consistency
every
across the bill.
clause makes reference to a person. So let's be consistent. A person, exactly.
It says both citizen and a person.
Yeah.
Very up.
You want to invoke the provisions of the Constitution in interpretation and enforcement, and Article 1, 2.
You just have to be a person. Both human and juridical persons. Anybody.
So, Chairman, we agree. We agree to the person. So that we avoid a situation where a citizen may be construed to be restricting the persons of people or categories of persons obligated to ensure the promotion of the proper human sexual rights. So here, whether you're a citizen or non-citizen, so long as you're dwelling in this country, you are bound by this act to take steps to ensure the promotion of proper human sexual rights. So we are amenable to the amendment proposed to replace citizen with the person.
Did you want to same? Otherwise, we'll move to 3.
No, 2-2.
We have flagged 2 for now. There are
Oh.
a few things that we have to look at. But if you are on 2-2, let's go.
2-2.
Yes.
Yes, Chair, I'm not a lawyer, but so permit me. If the language subject to, it means we are subjecting everything to the article. So I want to propose that we replace subject to in accordance with Article 39.
I think it's the same.
Is it the same?
Yes.
They are not the same.
Subject to.
Yes, it means the article is controlling the provision.
Yes.
So I think that's the intendment. That is the intendment.
So
Subject to.
If you avert your mind to the debates on the previous bill, because we are told this is a new bill, the question of this imposition of duty on persons in the country was questioned. And our argument was, it is a constitutional provision. Article 39 of the Constitution imposes a certain duty on all citizens. and the state and and organs of the state. So this is actually based on Article 39. So you make it subject to Article 39 of the Constitution. So it puts a certain weight. When it goes for interpretation before the court will interpret whatever provisions we've made here in line with Article 39 of the Constitution.
Yes. No, Chairman, my opinion is that the current rendition is proper, in the sense that Article 39 is what enshrines the cultural objectives of this country, and where, if I may refer the committee to Article 39(1), subject to clause 2 of this article, the state shall take steps to encourage the integration of appropriate customary values into the fabric of national life through formal and informal education and the conscious introduction of cultural dimensions to relevant aspects of national planning. It goes on to indicate the appropriate customary and cultural values that must be adapted and developed. And we are saying that this bill is a very sensitive cultural bill, which must be subject to the cultural objectives enshrined in the Constitution, specifically Article 39. And so this is a proper rendition for the purpose of through a legislative process instilling a proper customary value.
Ralph, thanks so much. Let me take advice from legislative drafting. Senator, subject to, in accordance, or federance, which one should we adopt?
Subject to, it means that we shouldn't go or derogate from the provisions of Article 39. When we say in accordance with, it also says don't derogate from 39. It's the same thing in this regard for me. Yeah.
I'm even of the view that instead of making it specific to subject to Article 39, we can say subject to the Constitution. And my reason is that if you go to Article 11, we also have the laws of Ghana, which include the customary laws of Ghana as pertains in the various customary areas. And those customary laws are not listed in the Constitution. They're not in the Constitution, so that means they're at large. So you have to look at the customary law that is consistent with the Constitution, and then you can add all of that to this. So you can say, respectfully, that subject to the Constitution, the following, then we can proceed from there. So any constitutional provision that we have not mentioned is deemed to have been referenced.
Okay, so the subject really, you have just had a different dimension of other, I'll be with you, Sam, of other provisions in the Constitution that may be covered under this. And I entirely agree with you. What we are debating now is whether it is subject to or in federance of or in accordance with. And so, but I think generally, absolutely. Yeah.
Chair, respectfully, if you go further in clause 9 and 10, we make reference to the Constitution and say subject to the Constitution. So both 9 and 10 are subject to the Constitution. So for uniformity and consistency, I'll agree with Acting Rankin that we should change 2-2. Instead of saying subject to Article 39 of the Constitution, just say subject to the Constitution so that it follows through the entire provision. Because if you read 9 and 10, we also make reference to the Constitution, but we don't make specific reference to which article. So we can just make it subject to the Constitution across the entire bill.
Yes, but generally, when we craft any law, it is subject to the Constitution anyway. So if you now say if you now specify, so we specify clauses in the Constitution and subject to that. But when we generalize it and say subject to the Constitution, as if some laws are not subject to the Constitution.
Chairman, that's why I agree with you that the entire exercise we are undertaking is subject to the Constitution. However, we may come across certain specific provisions which relate to certain specific articles in the Constitution, and it is well in line that you make such specific reference. And in this case, we are trying to invoke the cultural objectives of the Constitution, which is enshrined in Article 39. So there's nothing wrong with specifying the specific reference and indicating subject to Article 39 of the Constitution.
So should we add Article 11 to?
For the avoidance of doubt.
Should we subject Article 11 to?
Chairman, I think I'm amenable to that.
Then the reason we have to generalize it, isn't
No,
it?
the issue is that Article 39 is not under Chapter 5.
Deputy Ranking.
It's under fundamental director principles of state policy. And then there is Article 11, which is also in a different chapter. So then if you are going to be doing cross-referencing, the reason I'm proposing that we should do Article 39 and Article 11 is that we don't leave any doubts at all, especially Article 11.3. That is on the customary law.
Yeah.
That is on the customary law.
Yeah, that's fine.
Uh-huh.
Yeah, so
Article 11 mentions the hierarchy of laws. I am not seeing its relevance. Thank you. I'm not seeing its relevance to the provision under discussion because we are looking at the duty of the state to promote the cultural values. And we are referring to Article 39, which imposes that duty on the state. So subject to the duty given to the state, the following persons should also promote the cultural values as listed in the bill. In my view, Article 11 need not be mentioned here.
Can you avert your mind to 11.4 specifically?
11.4, the existing law shall, except otherwise provided one of this article, comprise the written and unwritten laws of Ghana as they existed immediately before the coming into force of the Constitution. And any act, decree, law, or statutory instrument issued made before that date, which is to come into force on or after that date. So it acknowledges that the customary law is part of our laws. But if we say subject to Article 11.4 or we use Article 11, what exactly are we saying? Because this is the hierarchy of our laws, which is being mentioned in Article 11. So when we say this provision is subject to Article 11, what exactly are we communicating? Yes.
Yes. The very last one, then we move on. When lawyers sit on the table, we will never agree on anything.
Mr. Chair,
Please.
I'm ad idem with her. I'm ad idem with her because Article 11 is talking about the laws that we have. It is, yes, the hierarchy of laws. So even if this law is within those laws, so we need not mention it because these are the laws that we have. 39 is a different thing, talking about making sure that we do this and this and that. So we need not mention Article 11 in here.
Anyway, Honorable Asante.
On this principle of referring the clause to the generality of the Constitution, I agree to that. But with regards to section 2 here, it's for emphasis, such that the content as contained in section Article 39 will be strictly enforced. So we shouldn't generalize it.
We are the them with that.
Please.
Like I said earlier, our contention was whether to say in federals or subject to. That was the initial argument. Whichever we use, I think the content will remain the same. And so let's move on. 3.
Chairman, 3 will have the consequential amendment we have done that you mentioned on relative to intersex.
Under 3 what?
That's going to be under 3 FII and 3 GII and even 3C. 31C, 31FII and 31GII. 31C, which we replace, so it will read, knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except in the case of a person who has undergone a surgical procedure You see, the issue is they don't want us to use the word correct intersex.
Just a minute. Let's do away with this. Senior, I'll come to you. Sam, do you want to repeat that?
So it will say, knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except in the case of a person who has undergone a surgical procedure. Because then we need to deal with it to correct a biological abnormality,
Okay.
including intersex.
Okay.
We need to deal with that bit.
Except in the case of
intersex.
Intersex. And then we end there.
Yes. So it means we'll make that correction there.
Yeah.
That's in 31C.
Yep.
And then in 31FII.
That's right.
Any other procedure that is intended to create a sexual category other than the sexual category of a person determined at birth, again, except intersex.
That's right.
Then in 31GII, undergo any other procedure that is intended to create a sexual category other than the sexual category of the person determined at birth, except in the case of intersex.
Yeah, the question I want to find out here is, now, including intersex, all sex are assigned at birth. All gender are assigned at birth, including intersex. Is that not the case?
Yes.
This rendition, we need to critically look at it. It would arise if we say that medically, an intersex person's sex is not determined at birth. But if the understanding is that we are accepting that medically, a category called intersex is medically recognized and assigned at birth, then the exception may not arise, because every sex, by the binary notion, is determined at birth. And every medical doctor will say that even in the case of intersex, the chromosome is a reference, whether XX or XY. So regardless the physical manifestation or the outward biological or external manifestation of the gender, the ultimate reference in assigning sex at birth is the chromosome. Yes, so once we don't have to complicate it further by creating exceptions. Sex assigned at birth is assigned at birth.
No, the exception that was created was to say that if there are procedures to be done on a normal person, except an intersex, to change the sexual orientation of that person, that is where the crime lies. So don't do any procedure that would change any normal person or any person of
Yeah, so, but the procedure in intersex, the surgical procedure in intersex, it does not reassign. It does not interchange. The medically necessary interventions that are undertaken on intersex
Do you have
persons
any medical doctor?
are not done to reassign. They are done to reinforce.
To correct, isn't it?
They are done to reinforce the gender
There is an
assigned
expert
at birth. So it never.
Oh, okay.
So there's never a case where an intersex person who has been born, and at the time the doctors are determining their gender, so make reference to their chromosome, and it is XX, and then by that reference have the authority to assign that you are female, and then later, because of the external biological manifestations, some certain interventions, they are only done to reinforce the XX chromosome reference, which was the basis for the doctors assigning the person a female. They will never undertake an intervention that will reassign the person's gender from a female reference XX to XY, a male. So that must guide us.
So
we don't further
we will.
complicate it.
Is there any medical doctor here? Okay, so we will pick your thought later. In the meantime, let me welcome the venerable chief whip, the government chief whip. Is here with us.
Chairman, thank you very much. Chairman, I think I appreciate what Honorable Intim Fojwa is saying. So, but I side with the proposal by the Honorable Sam George. So what I think the solution is, we should take out the intersex in this provision and create a separate provision for them to carry the argument of Intim Fojwa. In the sense that in respect of intersex, yes, you are not changing. You are only, yes, you are only correcting. Because intersex is from nature. No, you hear me. Because in respect of intersex, it is nature assigned. But it is neither on the left nor on the right. So now the person says, now I want to be dominant on the right or on the left. So I see where Intim Fojwa has a problem with if we want to use the word reassign.
So
in that provision,
before you come in, let's listen. Let's take the.
No, hear him. Hear him. So my solution would be that.
So from Chief Whip,
we create a separate provision to take care of intersex, but we'll not use the word reassign in that provision. We'll have to say assign. Yes. Because at nature, intersex, there's an ambiguity there. There's a presence of both.
There's a choice.
There's a choice to be made.
And the child doesn't have the capacity to decide. Somebody has to decide.
Chair, let's be clear on this. Okay. And there's a reason why two reasons. One, as much as possible, let us see how well we can present the bill to the plenary as practical as possible as it was presented in the last parliament originally. One. Two, the issue here that we are dealing with,
I think it's clear.
The issue we are dealing with here is just the stigma that biological abnormality, correcting a biological abnormality in reference to intersex brings. That's all. Because you see, when you talk about the surgery, and that's where I vary or differ from my brother and colleague Intim Fojwa. When you talk about gender reassignment, it is not a one-off surgery. It's a series of surgeries, similar to what may happen with an intersex person who is carrying out surgeries as well. Because when you have a man who is transitioning from being a man to a woman, and that's a gender reassignment surgery, it is not one surgery. There are a series of surgeries. So for example, if you had an intersex person whose dominant chromosome and all the tests show is a man, but has developed breast like a woman, and that person is going to do corrective surgery on the breast, that may not be done in one go. It may be a series of surgeries and treatments. But that same process is also going to be legal for a woman who is transitioning to a man and reassigning her gender, who wants to lose her breast and also go through the same treatment. Now, what this provision says is that that practice is illegal except for an intersex person. Because you can still have the same kind of treatments that an intersex person will go through, that someone doing gender reassignment will go through. And so that's why you should not take this out, because then it defeats the intention of criminalizing the procedure, which is what this bill is seeking to do. But we are accepting similar procedure if it is requisite for a person who is intersex. I don't know if you get the distinction.
Chairman, we are adding them on this. But myself and Honorable Sam George, we are speaking, and Honorable Dafiame, we are speaking the same language. But what we are saying here is that, yes, we recognize that there may be the need for medical interventions in correcting certain external features of a male or a female. Here, the primary reference of our definition, sex, when you go to interpretation, says sex, which is the fundamental definition around which every other provision, emanates, says that sex means the binary categories of male and female or chromosomal composition at birth and excludes any non-binary category. So what we are saying is that we are assigning the responsibility of determining sex at birth. And the medical authoritative reference is chromosome. And thankfully, we don't have any other variations of sex chromosomally except XX and XY. So when a person, no, you let me land. You appreciate.
So this is not dealing with.
No. You appreciate. Let me land. Let me land. So for instance, a female who has been assigned XX at birth, who later, unfortunately, due to let's say breast cancer, has to undergo a breast removal surgery, the person is doing so, and the person is not coming under any contravention, because it's a medical intervention. It is not reassigning any. But the same way, when an intersex person is born, the medical doctors have a way of medically determining their gender. Although, so the reference, everybody born is born male or female. You may have certain external manifestations which may need intervention, but that intervention, it is not tampering with the sex assigned at birth. It is only reinforcing. It is only correcting certain features that reinforce the gender assigned at birth.
Before you even come in.
Chair, no, just so that we are clear. Chair, just so that we are clear. The provision we are dealing with is not dealing with the determination of chromosomal composition or sex and whether you are male or female. That's why I'm saying that the Honorable Intim should read what we are dealing with. We are dealing with 3(1)(g).
Yes.
It says a person shall, this is under prohibition of LGBTQ plus and related activities. This is not about determining the sex of the person.
Yeah.
That's not what this provision is dealing with. The argument he's making is valid when you are dealing with determining whether the person's sex is male or female. But that's not what this is dealing with. This is dealing with the prohibition of any surgical procedure for reassignment. So at that time, determination has been made already.
Yeah.
But the question is that when determination has been made that you are male at birth, then you now want to go and do surgery to become female, to have a vagina and to have fallopian tubes. That's what this is dealing with. This is not dealing with whether you are male or female. That's been determined. If an intersex person is born, the predominant chromosomes are determined. But at a certain age, the person decides to take steps to correct any physical manifestation that is different from what has been determined at sex. What we are saying is that procedure is being exempt from being criminalized.
Absolutely. Yes.
So we don't need to go into
we are
chromosomes.
So we are good to go with this. Indeed, when
In a case where
yes,
in a case where the doctors let's also avert our minds. In the case where the sex determined at birth is XX, but still intersex, and then so assumed to be female, and then later on, under the guise of intersex, the person is undergoing medical intervention, which will make the person now XY. That is prohibited.
No, so
That person is not considered as an intersex.
yes, as an intersex. Okay, that's fine.
No.
Okay, so
Because
Mr.
you are saying under the guise.
Yes.
You are no longer captured under this provision.
So
The principle in law is to have 99 guilty people go through than have one innocent person criminally. So what Honorable Intim is
an extreme
is an
exception.
extreme exception of someone who is criminally minded to try to take advantage of the intersex exception to do gender reassignment. We cannot, out of that fear, create an opportunity or prevent the majority of legally minded people. So I would say that let's err on the side.
okay, so I think we're good to go on that. Initially, when he raised the issue, I had to go back to 1C, where we started correcting the intersect. And then that correction was very clear. It says, who provides or participates in the provision of sex or gender reassignment, surgical procedure, or any other. They are not conjunctive. They are all disjunctive. So it can either be this, that. Initially, the reason Chief Whip was saying we should make a separate provision was also of the assumption as if they were boxed together. So if we do any of this, then except in the case of intersex. So that we understood it clearly, and that will rhyme through. On that note, medical officer, please provide us, Ref, let a medical person
Just
provide
before
us
they come
with,
in,
yes.
I just don't want to be misconstrued. My contention here is that intersex people are within the binary categories. So they are not outside the binary categories. So that it further even removes the stigmatization that intersex people are not, within the binary notion. They are, because their gender is determined at birth. They are.
Okay,
So that
Doc,
should
in
not
the
be
light of the
misconstrued in-
discussion that we are having now, just educate us briefly in just 2 minutes.
Can you give him a microphone?
Please, of the mic.
So now your microphone is not working. You want to turn it on? Turn it on.
Hello.
Yeah.
Thank you very much, Mr. Chair. Okay, so just to put it in simple terms, so the sex determination, we have the genotypic sex and phenotypic sex. Genotype is where Honorable Intim Fojo mentions that XX or XY. However, phenotypic sex is what we see on the outside. What we see is either male or female with our eyes. Intersex is a variation of condition, not one condition. So if somebody is born XY, there are some conditions that can make the person appear, the external organs will appear as a female.
Yeah.
So such a person, if he's diagnosed as intersex, those procedures are not sort of gender reassignment. They are for treatment, for medical purposes.
That's right.
So such a person is being treated, that's where the exception comes in.
Okay.
However, if the person is XY, everything is male from outside, from inside to outside, and grows up and decides that, okay, me, I want to turn into this, and that's where the other one comes in. So once we make the exception that intersex is exempted, it means that person is first of all diagnosed as intersex, and then whatever necessary is done for the person. So that person should be exempted from the others we are talking about. Thank you.
I think
Very well.
Exemption is not in doubt.
Very well.
exactly. That's why
Yeah.
I'm just saying, except what we are saying, reassignment. That is where.
No, so reassignment, it's a disjunctive. It is this or that. So whichever is applicable to the intersect is what we will use. Three.
I need that clarification. Just for educative purposes.
Yeah.
You can have a situation where someone is born at birth, but it's not determined, to the extent that they may have to perform some surgical. Most often they are females, just to open. It's a biological procedure, all right, just to open some parts in order to let it be defined that it's a female. You get it? When you undergo such a procedure, my worry is taking out undergone surgical procedure is a problem. Because when you look at 3C, knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except in the case of intersex. But someone can be in a situation that I just explained. It's a medical procedure, all right. So holistically taking out medical procedure is a little bit problematic.
Let me address that, Chair. So in the situation that the honorable member has explained, a female is born, but may have, and with the greatest of excuse, the vaginal pathway a person is born, and the person has been determined by chromosomal checks to be a female, but maybe the vaginal pathway is blocked or is born sealed, and so an opening is done. In that instance, it's not gender reassignment. So what we are talking about here, that's a medical procedure. So the surgical procedure is for sex reassignment or gender reassignment. And these are specific terms which will refer to a man. A defined person is being checked, the person is a man. Then he says that reassign me, remove the penis and create. That is what we are frowning upon. We are not frowning upon corrections. I mean, when women go to have birth, give birth and things, they have tears, they are surgical procedures, and those are medical procedures that are not covered here. This is specific if it is a medical procedure for sex reassignment or gender reassignment. So it's not an omnibus thing on all medical procedure. No. It is on the reassignment of sex or gender.
Yep. Senna, before you, Senna.
I think we should look at the 3C again. 3.1c. A person shall not knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except intersex. Except in the case of intersex. But if you go to 1c, we use the word surgical procedure, which is missing in 3.1c. And I think what Reverend Tim Fojo is saying is that in the case of intersex, it is not a sex reassignment or gender reassignment. It's a surgical procedure.
I think I have my challenge with this.
Let me respond to Senna. Senna, in 1C,
you can't marry an intersex.
you are only speaking about all the people. You are talking about all the people who this bill would apply to. It will apply to people who have done sex reassignment, gender reassignment, or undergone a sexual procedure. Now, in 3, you talk about, in 3.1c, you are dealing specifically with, you are saying that you are prohibiting anybody from marrying someone who has done a sex reassignment or a gender reassignment. However, if the person has done, except in the case of intersex, so if in the case of an intersex person, the person has had a medical procedure, that is not criminalized, and you are not prohibiting the person from marrying that person. So there is no conflict there. Because in 3.1c, what we are saying is, you can't marry somebody who was a man and has transitioned through gender reassignment to become a woman. That we will not recognize.
Mr. Chair, I think that I want to go back to the proposal by.
Is that the same or
the same thing. It's the same thing. It's the same thing.
Before, okay. So
the proposal by Honorable Sam George, when we're considering 1C, may be very, very helpful. Where he proposed that medically a procedure medically necessary to address innate variation in sex characterization, including intersex. Now we are saying that a person shall not knowingly marry or purport to marry a person who has undergone gender or sex reassignment, except in the case of a person who, and then we insert your medical term there. It may not run through, but it may be a one-off or where necessary, we insert it. I think that we should have to consider something. So this is one good example of a place where we should be specific, because you can't marry an intersex. You can marry an intersex, but but you see, the issue is that the person may have changed, and then we are considering a person who has been reassigned.
There are intersex people who are married.
I'm saying that we are looking at a situation where we have to go back to your definition, where the person may go through. Are we saying that an intersex is okay to marry any other person?
Yes.
You think that with the person's
The person
sex
is fine.
variation?
The person is
Well,
fine.
that's it.
So long as their partner is okay with
It's a
it,
decision.
that manner,
Okay.
it's a decision that they will make. We are simply
Otherwise,
saying
we'll be
that-
compelling a person to
Yes,
to
then you will
undergo
not be compelling
the
a person
procedure.
to make a procedure.
Well,
So that's why I think that we should leave it this way.
So with avoidance of doubt, because we are carrying the public along. With avoidance of doubt, this bill, in the previous and in the present, it is not seeking to target intersex. It is not seeking to deny intersex any marital privileges or sexual privileges. And that is why we also recognize the special categorization and the interventions that medically necessary.
The reason we
they
are
may be
exempting them.
requiring at various stages. The reason we are exempting. So they are exempted. The contention we are giving here is my argument was to further even enhance the removal of stereotypes, so that people do not see intersex people as attaching stigma. Absolutely, because their sex is determined at birth, and then as they go on at various stages, certain interventions medically are necessary to reinforce that gender.
Okay, that's fine. Let's move on. What would you define as a non-binary as part of your 3EIX?
3EIX.
Yes.
It's been defined in 18. Non-binary means a sex categorization other than male or female. Because there are people who today in the LGBTQ community hold out not as a he or a she, but as an it or as a they. Some people recognize themselves as objects. They don't want to be categorized. Binary definition of gender is male and female. There are people who say that they are neither male nor female. And so we are holding those people, we are prohibiting such expressions in Ghana. So that's what we mean by non-binary.
V-I-I-I, an ally.
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 An ally are those who...
An ally. does that include a health worker?
So
read your definition.
Yes. So an ally is defined as a person who produces, procures, markets, broadcasts, disseminates, publishes, or distributes a material with intent to promote an act prohibited under this act. B, evoke the interest of a child in an act prohibited under this act. Or C, teach a child to explore a gender other than the binary category of male or female. So, for example, if you have a health worker who is actively prescribing testosterone to a woman to help her transition, that person is carrying out an act that is promoting an act prohibited under this bill. So, or a teacher who is teaching children that it is okay for a boy to fall in love with another boy or a girl. That person is considered an ally. Allies are largely heterosexual people who themselves are not engaged in any LGBTQ, but promote the activities for in many instances, financial gain. So many of the rights groups in Ghana are led by heterosexuals who are busy pushing that we must recognize homosexual rights, meanwhile they are heterosexual, and claiming that it is human rights. So allies are a category of persons who themselves may not be practitioners of any of the prohibited acts here, but are promoters and encouragers and facilitators of the acts we are prohibiting.
That's the most
They are abettors. They are more or less abettors.
So,
and you can abet in so many ways.
We are going
Let
to
me
go
give
on
you
this.
a practical demonstration.
Yes.
I have a book in my hand, and Chair, you may even look at it before I put the relevant pages in it.
The book reads Physical Education and Health, Ministry of Education for Senior High Schools, Teacher Manual.
Please, turn to page 3.
Let me help you.
No, let him explain.
No, this book, this has drawn.
No,
It's still in the system. It's still.
It was introduced in 2020.
No,
It was introduced
Well, we are good to go with what we're looking at.
All right, so
Now, one,
Chairman, let me make a point.
1 and 3.
Chairman,
Chief
let me
Whip.
make this point.
Chief
This
Whip,
book-
you're out
this
of
book-
order. Let me remind members that this is Parliament.
You are in charge.
Yeah, that this is Parliament. Now, the words hold out as used in both 1 and 3. I'll come back to you. In both 1 and 3, please look at it again and see whether we should not replace that.
Mr. Chairman.
Look at 1, not just
Mr. Chairman, we should not replace them. We
You
should
see,
keep them.
1A, a person who holds out us. Promoters, a person who holds out us under 1A. Then if you come to 3E, 1E, holds out us. Why would we not just go straight and say a person who is, rather than holding out?
Chairman, no, hold out is not speculative. That is what they actually
So please explain.
Now, the contents of this bill essentially is a replica of the law that we actually passed that didn't get assented to. My fear is that if we tinker with a lot of the provisions and we get back to the floor, because what we took to the floor in the original bill was what was reduced to what we have now as a primary product. So my fear is that if we water down these crystallized clauses and we go back to them, it's the same people essentially.
We will still look at holding out. A person who holds out.
No, hold on.
And a person who is, because that's what we want to deal with.
I remember this provision very well. It was debated for like 3 days. Eventually, it was the leader of the house who I think this language came from him. I recall very, very well. So I pray that if we think out of it and we go back, it will survive. Otherwise, then it may be reverted to
holding out. Who has a different view to holding out instead of who is?
Mr. Chair.
Yes.
A person may hold himself out or may be held out. Now, the danger is that a person may be held out as a lesbian or gay, and the person is not.
Yes.
But in this case, it's the positive acts of the person.
That's the person holding out.
This is the person who is holding himself out. I am gay. Positive manifestation and saying to the whole world that I am gay. So if you don't leave it this way and you leave it to the good or bad judgment of people to hold people out, you may be holding out the wrong person.
At what point would you be charging that person? Is it when he tries to hold himself out or when you think that he is?
All right.
So beyond, you see, holding out in itself is a manifestation which is against the law, number one, and committing an act pursuant to the holding out is also another offense.
Mr. Anand,
So if you are being charged, Mr. Chairman, let me just learn. So the person may be charged on 2 counts. 1 for holding out, and 2 for engaging in an act, which is also pursuant to it. You see the point?
That's fine.
So let's
Just to support him, Chairman.
currently, one of the biggest challenges we have is people who are on social media holding themselves out as one or two of these expressions and publicly doing manifestations. The law is saying that, and withholding themselves out in that mannerism, are actually encouraging and influencing people on social media to embrace that. We must be able to hold such individuals responsible for that public expression. That is separate from when you find somebody in the act. And that's where I agree with Honorable Tampuli, that this will create two different charges. One of holding out. So I don't want to mention a particular name, but there's a particular person on social media who is constantly dressing up and holding himself out, a man as a woman, and is being even celebrated at public functions. Such a person can be charged under this law if he passes out for holding out as a lesbian.
So that's good. Dr. Annan.
I think if we don't take care, we make things look so broad, and this law must also meet the criminal test. I mean, the principle of criminality, what amounts to criminal culpability. The two must go together. The Artus rules and the mens rea. So if I say I'm an armed robber, or I believe in promotion of armed robbery, does that amount to criminal liability? And if you don't take care, this will leave room for people to stigmatize and speculate. So it's very dangerous to say holding out. Holding out means that I can hold.
No, that's not what the bill is saying. The bill says a person shall not hold out. So you do not hold me. I hold myself out.
Not holding you. Holding can be your dress, your appearance. The way the gesture.
All right, so let me explain.
Chairman,
let me explain and make
this is Parliament. In Ghana today, there is a gentleman whose video has been there's a gentleman for whom a video was leaked and an altercation between himself and a male lover of him came up last year. A gentleman known as Educator. Now, he can be charged on the basis of the video of male and male intercourse. That is a different thing. But aside from that video that came out, that individual holds himself out and promotes homosexual activity on his social media page. That person is holding himself out, so there is an act, and there is the actus rules and mens rea can be determined from his activity. So you take his activity on social media, his public commentary he has made where he admits to what his sexual preferences are.
So he can't make that statement.
So
he's not allowed to make that statement.
It is not just about making the statement. That the actus rules then goes to what has he been doing. The statement is an evidence of the mens rea, the thinking. But the actus rules is in what has he done to actualize the statement that he is this.
So those two, so those two must go before you can ground a cause of criminality. So take for instance the example Dr. Annan gave. I am an armed robber. I hold myself out.
Yes. Tomorrow I'm going to rob.
Yes. Or no. Yes. So if it says
it's not enough to say you are a murderer.
That's right.
I killed this person.
That's right.
But you must show that you killed the person.
That is a reason you must not say holding out.
Fine. But you see, offenses are not the same. All right. This particular offense that we are doing, it is not like any traditional offense that we have known.
Hold out.
No, please.
That's what
and we are saying that holding out as a murderer will not encourage people to become murderers. Holding out as a lesbian, because of probably your social standing, it may create a certain impression that it is okay, which in fact is against our cultural norms. So we must look at this offense like on a case-by-case basis. Let's not try to generalize and say that, yes, I agree with you. The fact that you say you are a murderer doesn't mean that you are a murderer.
All right.
You must murder before.
We are done with you. Fifi,
Thank you very much,
Quickly.
Chairman. Thank you very
I'll
much.
take 3 more on this and
Thank
then we'll
you.
move. Yes.
Chairman, this is.
I'll come to you. Oh, yeah.
This, this law or
me the
this
opportunity.
bill we are looking at is criminalizing an act. It's criminalizing an act. And in our criminal jurisprudence, Mr. Chairman, if you say somebody is a thief, it means you have judged that person. We are not practicing the inquisitorial system. It is the adversarial system. So holding out would best describe what we are doing so that the person will be charged. Because if you arrest that person, the person, it is not like a strict liability something that you would come out and say that I am not doing this, except that you are making it a strict liability offense. But if you are not making it a strict liability offense, then the holding out, I believe, is perfect to fit in. He has held himself out. We charge the person, we caution you, we investigate, and we charge you.
Very well. Rankin.
Chairman, thank you.
Yeah.
I think that the present rendition is good. Holding out, if you look at our laws, we have inchoate offenses. They are different from substantive offenses. Of course, that is why when you engage in the act proper,
you're out of order.
that is why when you engage in the act proper, you can be charged on that one separately. You understand? So the whole idea is to discourage people from encouraging and influencing others in that line in terms of the sexual orientation and all.
And then we'll move on. Holding out.
Yeah.
Strictly on holding out.
Yes, holding out.
Okay.
Chairman, this is a bill that is criminalizing the promotion, propagation, and support, advocacy for. So even category of persons who don't even hold themselves out as, who don't even engage in the act, but promoting, supporting, and advocating such practices are even deemed as contravening the law. What is more advocacy and what is more promotion than somebody who is holding themselves out, claiming, brandishing, and touting themselves as persons practicing these LGBTQAP blah 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 blah. That's the height of the advocacy. So if you see anything problematic with holding out, then you find something problematic with the criminalizing the prohibition promotion. And here, this is the mischief we are curing with this bill, which the Criminal and Other Offences Act 1960 Act 29 could not. And that is why it is important and proper that at the very instance where the person holds themselves out as, whether for purposes of securing visas or for purposes of advocating, for purposes of making the practices, however perverse they are, more attractive, the person must be held liable. And that is the intendment of this bill. Thank you.
Procuration. Oh, yeah. Doc. Mike, please.
Look at
Thank you very much, Honorable Chairman.
Yes.
I humbly just want to bring to the attention of the House, also having taught criminal law,
I told you.
what we are dealing with is what you would call status offenses, which is the state of a person. Increasingly, countries are moving away from that because it is very difficult in practice to actually prosecute such. I heard eloquent arguments being made, for instance, with inchoate offenses. Even there, as Dr. Annan indicated, even if it's a mental crime, like conspiracy, as it were, you would still have to establish both its mental element and then its action, which may well be in the head, as it were. So, yes, like threat. So countries have been careful rather to be more specific around actions. And that's why even in what we are discussing, if you look at our sister countries, Uganda, Nigeria, their laws tend to be more definitive of actions rather than the state of the person. So I only humbly submit that we perhaps, if you had even said a person is, as Honorable Member you indicated, is might actually be an easier way to work things out rather than hold out, because the spectrum of holding out or the status of a person can be so broad that in actual practice, it might actually be impossible to find anybody to prosecute. So as you consider any criminal legislation, consider also the opportunity for defense and what people can come up with. So that is just to place on the table that as we look at this, contemporary criminal legislation, it will be more for actually stating specific actions you want to prohibit rather than the status of the person who would commit such an offense. Thank you, Honorable.
Dr. Foley, at what point will you say, for instance, in section 1, at what point will you say this act applies to a person who is a lesbian, who is a gay, who is a bisexual? At what point will you say this is a who is?
It means you have to prove.
Doctor, now you're out of order.
I would respectfully even steal his point out of order because it would impute a certain presumption. And so you would want to actually specify, right, specify. And you are saying prohibited acts. There are people who, for the want of a better term, if a school is organizing any function, right, or for drama or anything, and they cross-dressed, right, for cultural expression, they cross-dressed, is there a criminal intention to promote?
That will not.
Allow. Hey, Rev.
Concern is addressed.
Rev, allow. Doc, continue.
Yes. And so you would want to be very specific on those prohibited acts rather than. So if they are exempted, then you also want that to come very early in the law, so that anyone who is reading it is clear in their mind. Otherwise, from the beginning, you're going to run into problems. So I only say that we should be careful around status offenses. And increasingly, we are moving away from that because they are quite difficult to prosecute. I'm looking at the hereafter of the law, and you may not be able to actually catch anyone. Yes.
Fifi and Sam, judging from your, I'll come to you. Who is? If you go by who is a lesbian, a gay, a bi, whatever.
Chairman, you must read the preamble.
Right.
A person shall not. You can't say a person shall not who is.
No, I'm talking about
who is.
I'm talking about one.
Yeah, but one has a preamble. A person shall not.
Yes. So a person shall not.
Because that deals with A, B, C, D before you get to E, which says hold out.
Yes.
And so, Chairman, let me just give you a fantastic example. And maybe this will make the whole room laugh a bit. There's another individual called Angel Maxine. Angel Maxine says that Angel Maxine is a male who claims that he has transitioned to a female and has held himself out on TV and done music videos, and now claims that he is having intersex with Honorable Intim Fojo, and that Honorable Intim Fojo is his gay lover. Now, on that person's claim, that person is holding out and making such claims. Tell me how we managed to prosecute these ACP Agodro and others on the basis of a text message in a WhatsApp group that was a conversation that we were able to find criminality and prosecute. But why are we saying that someone like this individual who has gone out to hold out and is even making such claims, we are saying we can't hold the person is not holding either, that is not prosecutable?
Chairman, my name has come up. It is important I respond. Mr. Chairman, I want to state categorically, I have never been gay. I have never been any LGBTQ.
You don't have any friends.
I have no intercourse whatsoever with Angel Maxine.
in her old or present life. No, it's important. In her old or present life, as contrary to her claim, contrary to his or her claim that she has had some, perversive intercourse with me, I've never engaged in any sexual intercourse apart from what God created between Adam and Eve. And to state that the concerns that doctor and all my friends have raised is addressed in clause 7. Here, we for the purposes of this act, grossly indecent act means public show of romantic relations between among persons of the same sex, public show of romantic relations between or among persons where one or more of the persons have undergone gender or sex reassignment or cross-dressing to portray that the person is of a gender different from the gender determined at birth. But the catchword here,
are they holding out?
No, with intent to engage. So that is addressing those concerns that people who cross-dress for cultural purposes, there is no intent. But the person who is claiming, self-confessing, posting videos and acts, and identifying clearly beyond a doubt that they are LGBTQ who fills a form with all fidelity and indicates that they are LGBTQ for whatsoever ulterior purpose, has given sufficient prima facie grounds for which they should be liable under this act. If we fail to uphold the holdout, then what is the foundation of the mischief we are trying to cure here?
No, so for purposes of clause 1, where the act applies to, should we be applying it to holding out, chaps?
For the purposes of this act.
Yes. Should it be applied to persons who are holding themselves out or to the real people?
Chairman, the one who is holding themselves out have even
allow others to also contribute.
Gone beyond.
Mr. Chairman.
I've gone beyond being.
Please, Kofi, come in.
Mr. Chair.
Kofi, come in.
Mr. Chair.
No, a minute. Kofi, come in.
Mr. Chairman.
Yes, please.
Mr. Chair, I hold a privileged position.
No.
Mr. Chairman, I hold a privileged position in this committee. I'm in leadership. So, and so when we go for vetting, leaders can intervene anytime. Leaders should be able to intervene at any point in time.
Let the table come first before leadership.
Mr. Chairman, you have to give me that privilege.
Kofi.
Mr. Chairman,
yes.
If we want to look at this qualification as in people are, then obviously we will not get anybody, because with the natural definition of sex, gender, there is male, female. Beyond this, there cannot be anybody we will see here and say, this is a lesbian, this is a no, unless the actions, utterances, or behavior of that person purpose to tell us that he is doing that. So I think holding themselves out, unless of course probably the rendition here, this act applies to a person who holds out as. That is where I have a problem. But you say if we can say who holds himself or herself out, because we know that every human being, the sponsors have told us, is either a male or a female. So if any person holds him or herself out as being this, then we shouldn't be looking for it, because it would never happen that somebody will become a certain gender called lesbian, a certain gender called bi, whatever. But the actions and their utterances, we will hold them also out as such.
Thank you so much. We are done with holding out.
Mr. Chairman.
We are done with holding out.
Let's move on. I have the last bite. Mr. Chairman, Mr. Chairman, you have to
let the high table.
Yes, Mr. Chairman, you have to give me the profound honor of associated with being in leadership. Exactly, Mr. Chairman, you have to do that. Mr. Chairman, we have to be conscious of this fact that what we are dealing with here goes beyond the act itself. The most potent crime that I see is even way beyond those who commit the offense. And that is why you find under clause 11 or clause 9, for instance, a person who contravenes subsection 1 or paragraph 1 commits an offense and is liable on summary conviction to a term of imprisonment not less than 5 years and not more than 10 years. Now, if you look at those who commit the offense. The sentencing regime under this one is even more than those who commit the offense. Because if you hide in your room and go and engage in any sexual activity, nobody is going to see. And you are not likely to corrupt anybody. But it is an outward manifestation that we must discourage more than even the performance. Because nobody, even those who are engaged in heterosexual sex, do they come and do it publicly? They do it in the comfort of their homes.
Hold out.
Please, let's continue to hold out. Let's hold out. Let's hold out the holdout.
Senator, tell me your views on it. And Chief, we will have the last one.
I think it will be more difficult to find somebody who is a lesbian. You have to prove even more than one sexual activity, because you are saying the person is a lesbian. Proving that will be very difficult. But the person who holds out, who expresses, who represents that he's a lesbian, that will be easier
To be a starting point for investigation. Chief Whip, very last one.
Chairman, I've been hoping that Senna would have defended this matter long ago. Because this matter, this holding out, was Chairman Sabuzu's expression. And he defended, that man is...
And Senna helped him.
Senna was in the meeting. Che is a Westmead. He explained the holding out in English. So yes, because we are drafting, we are using English. We are drafting the law with English.
Yeah, he trained me and you.
Yeah. So he trained us. Precision. We brought all sorts of things. Eventually, when he used the phrase holding out and explain it, it was okay. It was okay, because you see, it's by conduct. The things you say, the things you write, that is where the promotion comes from. That is where, you see, you are dangling the carrot. That's where people get attracted.
Okay, now you have made reference to Che. We can leave it that way. Because he trained you and I on drafting. Very well. So we can move on to 4 now. Procreation.
I have something on 3.
Okay, so on 3 again, but not on holding out.
No,
from this
holding
and
out.
then you. Yeah.
So 3, A, B, and C.
3.
A, B, and C. So if you take 3, A, for example, for the purposes of this section, sexual intercourse occurs where a person penetrates the anus or mouth of a person of the same sex with the penis of that person or other device. So my concern is with the other device. So if a health worker penetrates the mouth of another person with...
The intention is not to commit an offense.
Chairman,
so
if I may respond to that.
No, let me land.
Other than...
Let me land.
Let's because of that we don't even go further. If you read that, you read it with the end for sexual gratification at the end of D, because it's a whole thing. You must read it in whole. So you read it, it will say, for this purpose, for the purposes of this section, sexual intercourse occurs where a person penetrates the anus or mouth of a person of the same sex with the penis of that person or other device for sexual gratification. That's how to read that whole clause.
For sexual gratification.
So
sexual gratification.
From the preambular statement, it carries A, B, C.
So a medical practitioner doing what they are doing will not get sexual gratification.
Chair, I'm okay.
Yes, very last one on 3.
Thank you,
Then we
Chairman.
move on.
Let me make reference to the same provision. That is
Yes.
clause 3, subclause 3, D.
Yeah.
Chairman, just like Honorable Sam George said, the D, the phraseology for sexual gratification, the intent is clear that it is applicable to all the sub-provisions here. But as it stands now, it doesn't look so. I think that there must be a semicolon after D, the word animal, so that it will demonstrate clearly that the phrase,
Very well.
there must be a semicolon.
Or
Yes.
even alternatively, for purposes of this section, sexual intercourse occurs where a person, for purposes of sexual gratification, then you come
Yeah.
with A, B, C, D.
No,
Z.
these
There's a controlling.
These
There's a controlling provision that
These are
holds.
drafting. These are drafting issues. Senate has taken note.
Bring it to the top.
Yeah, so it comes to the
Yeah.
top and then to control.
4. Procuration. We will break for lunch at 2 o'clock. Before that, we want to do 4 clauses before we go for lunch. I'll control that, and we will have to go by that. Okay, so 4. Yes.
You mean we'll end at 4? No, Mr. Chairman, you cannot determine that.
Mr. Chairman has the power to determine that.
Mr. Chairman, you don't have the power to determine that.
You're out of order. It's challenging the authority of the chairman. Yes. So 4. Are you on 4?
I just want to bring us.
Please 4.
Are
you on 4? No, you can arrest it when we go past that.
Otherwise, when we go for second reading.
When we go for second reading, you arrest it.
Because, Mr. Chairman, I was looking at, as a lawyer, I'm looking at it with a defensive.
Which one are you looking at with a
3. 3. Yes, 3. We are saying that penetrates the anus or mouth of a person, blah, blah, blah. Okay, what about if the two of them, man and 2 males, they don't penetrate the mouth or anus, but masturbate?
Is it for sexual gratification?
Yes.
Yes. So they are covered.
So it is not. It is. That's not in. It's focusing on.
Masturbation is going on everywhere in this country.
Let's take our time and look at it. 2 men.
Mr. Chairman, masturbation and use of toys are already going on.
No, Chairman, what Fifi is raising is very critical. What Fifi is suggesting is that in the provisions as they stand now, we have not captured the act of 2 gay men masturbating each other, stimulating each other without penetration. Because if you look at A is supposed to deal with what you call gayism. B is supposed to be lesbianism, and then C deals with bestiality, and then D with all the other variations. But if you look at the way A is couched, which is for gayism, it supposes that the only actions that we are criminalizing between gay men is the penetration. But you see, if you look at the female one,
what do you suggest?
So it will be stimulate or penetrate the anus or mouth or any other bodily parts of a person of the same sex.
That's all.
So I'll take it again. Stimulates or penetrates the anus or mouth or any other bodily or maybe reproductive organ.
So then we have to define stimulates.
No, stimulate is already used in the B.
So let's define it for effects. You understand? It's very important.
Sexually stimulate.
Exactly. Sexually stimulate. Let's be very.
So stimulates or penetrates the anus or mouth.
Sexually stimulate.
Yes.
Gratification is in the stimulation. Yes.
The gratification is in the stimulation.
It's innate.
So want us to take gratification out.
No. Where what I was talking about is just about not. It is going to.
Vivi, can you couch it for us? Let's see what rendition. If you.
Yeah. So what he was saying, I was following.
If you go in line with
what
it. He appreciates your point. So please.
I said stimulate or penetrate.
Senator, take note.
Stimulate or penetrate the anus or mouth or any other bodily part of a person of the same sex with the penis, with the penis and hand or mouth of that person or other device.
What about tongue?
Tongue is in the mouth.
The tongue is part of the mouth.
The tongue is part of the mouth. So it will be, because right now, if you are doing what he's doing in the first part, you have to fix the second part, because if you leave only the penis,
it
doesn't capture. So it's the penis, mouth, or hand, or any other device.
Yeah, that's all.
Okay, so my issue is that A, B, and C, we haven't used stimulate.
So it will now control the rest.
Okay, the stimulating B. So to send out to be consistent, you use stimulate or penetrate. Yes, throughout. A, B, C. Yeah, for ABC. No, it's at the end there.
Where a person for personal sexual gratification.
If you qualify the stimulation with sex,
Sexually
use it to modify the gratification. It applies to all.
Okay, so we will leave that for drafters to
I
couch
think
it.
she's gotten the, yeah.
The intent is the activity. We are already.
About gratification, if both a means and an end. So is it's an ongoing and then a terminal process. Both the means and the end.
Very well. Senator, please couch it, and then before we leave, you will let us know how you've. Four, please. Procuration.
Mr. Chairman, number 4 should remain and stand without any amendments. I beg to move.
Mr. Chairman, seconded.
Mr. Chairman, on your behalf, we'll go to number 5.
No, so let's procuration.
We'll finish it, Mr. Chairman.
Mr. Annan, do you have something on 4 procreation?
Which one?
Legal aid. Procreation. Are we cool with that? Very well. 5. Detention with intent to commit prohibited sexual activity.
Proposal here. A person shall not, by use of threats. Number 4. Take a look at. Use of. Yes, by use of. Yes, I think. Yeah, by threats is it's a bit empty. By use of threats. By use of threats. Obstruction.
Chair,
By use of
coming
deterrence.
back to procreation, I think we did say that the criminal offences are.
Yeah, that's what I wanted you to avert your mind to.
Has captured it, so we just have to lift.
Please check what you did there on procreation. That's 4.
Yeah, to align. So somebody should read that.
107. Yes.
107A or
107E and F.
Is it Article 107?
Section rather.
Section 107.
Yeah.
You want to lift that into
Procreation.
No, we want to align. Or is that not?
Align with, yeah. Section 107E and F.
So propose amendment.
So Act 29. Okay, what is in Act 29? Please.
Section 107.
So please, whoever has the
Hey,
as you read.
Chairman, let me read what 107 says. It is quite detailed. Procuration. 107.1. A person commits a misdemeanor who A. procures another person under 21 years of age who is not a prostitute or of known immoral character to have carnal or unnatural carnal connection in the Republic or elsewhere with any other person, or B. procures another person to become a prostitute in the Republic or elsewhere, or C. procures another person to leave the Republic with the intention that that other person becomes an inmate of brothel elsewhere, or D.
procures another person to leave that other person's usual place of abode, which is not a brothel in the Republic, with the intention that the other person becomes an inmate of a brothel in the Republic or elsewhere for prostitution. Or E, by threats or intimidation, procures or attempts to procure another person to have carnal or unnatural carnal connection in the Republic or elsewhere.
This is where we should lift. So let's lift E.
What, E?
E. So a person.
E will say by threats or intimidation, procure or attempt to procure another person to have carnal or unnatural carnal connection in the Republic.
But this one is more extensive.
But you see what we have in the bill again. Let me make reference. Let me make reference to Honorable Chairman Sambonsu. This was another introduction of Honorable Chairman Sambonsu, not the clause but the additional words. We made reference to this, but the rendition that had threat, obstruction, deterrent, improper or corrupt means, molestation, intimidation or inducement, false pretense, and false representation were added because of the peculiar nature of what we are dealing with. Because you see, what you have in Act 29 largely deals with prostitution. Largely, you understand me? But this deals with the economic reason why young people were being drafted into this. And that's why we had all of this. So I think that we should stick with what we have, Chairman.
Dr. Foley, on 4,
I think I would go with
Dr. Foley and Dr. Annan, can you please advise on what?
Right. Thank you very much, Chair. For consistency, we were proposing, just as Honorable Sam George has indicated, to say, for the purposes, I'm just reading this rendition, for the purposes of this section, procure includes the use of threat, obstruction, deterrence, improper or corrupt means, molestation, intimidation, inducement, false pretense or false representation, and shall be construed consistently with the meaning of procuration under Section 107 of the Criminal Offences Act, so that the two are tied and there's no ambiguity. So this addition, yes, also works with 107. Yes.
So how do you draft that? Doc, please repeat that for Senna.
Right. For the purposes of this section, procure includes the use of threat, obstruction, deterrence, improper or corrupt means, molestation, intimidation, inducement, false pretense or false representation, and shall be construed consistently with the meaning of procuration under Section 107 of the Criminal Offences Act 1960, Act 29.
So this is a subclause. This proposed amendment will be subclause 2. After the existing one, what Doc has proposed will be 2 before what is there as 2 becomes 3.
No, so the drafting department will align it. So do you appreciate the addition that Dr. Annan and then Dr. Foley?
What end it will be that? Because the provision in 107 is on procreation. And the provision here is also on procreation. The provision in the bill is talking about procreation to engage in a sexual act prohibited under this act, which is the lesbianism, gayism, and all of that, which is not catered for here in 107.
Yeah.
So when we say it should be construed consistently with this act, I don't know what we want the court to do in that construction.
It's because of the scope.
The scope of this act is on matters mentioned in clause 1.
Yeah.
So nobody should procure another person to do any act prohibited under this bill.
Yeah.
In the Act 29, the provisions are also clear. Nobody should procure another person to do the unnatural carnal knowledge as used in 107. So I think there are 2 separate provisions. It is not necessary to tie one to the other.
But they are all dealing with unnatural carnal knowledge in the way.
You see, we haven't used unnatural carnal knowledge in this bill.
Yeah.
It doesn't need to.
No.
When men and men are having sex, it's unnatural.
And we have provided for
And
that.
was the mischief we are trying to cure.
But we have provided for men and men having sex in clause 3.
So we are saying that it is maybe the way, the language. Maybe when we say consistent, maybe in addition, maybe that will be more, because the whole essence of the bill is to deal with unnatural. Yeah.
No, but Chair, let me just ask:
Chairman,
is
let's
there
leave it
any
as it is.
provision in 107 that this rendition does not cater for? Is there any provision that 107 makes that our current rendition doesn't cover?
No,
If there is nothing that 107 brings in addition to this, then it becomes superfluous to keep, because I think that actually the scope of what we have is actually wider than the scope of 107. So if you then want to tie it to 107, you would have opened the scope in your initial text, and then you narrow it again with tying it to 107. So if there is nothing in addition that 107 does, let's leave what we have.
Dr. Foley,
Chair, I'm here.
would you be comfortable if we go with the original rendition?
Can I say something?
And does that, yeah, let Dr. Foley come in first before Dr. Anand.
The scope is rather wide, and also, I mean, we just felt, just for the avoidance of doubt, and yes, my sister, I agree with you. You may be wondering, and I have great confidence in the courts that if you rather put it this way, you make it easier for the judges to work with. So we would rather we have a rendition that has reference to, as we see, you have the Electronic Transactions Act, which would make reference to the Criminal Offences Act. So that was what we were trying to get across, so that you have that harmonious relationship between the two pieces of legislation. Perhaps you with your drafting skills can do it better, but the intent is to ensure that we don't leave any gap anywhere, since we already have a provision in Act 29. That was the intendment.
Yeah, this is okay.
Chair,
Let's just stick to it.
I think just to add, emphasize, it's the same thinking, because we've imported some words into this, which seeks to more or less broaden the scope of procreation as defined by the Parent Act. But we are saying that consistent with the, criminal jurisprudence, certain words that you import here may leave room for some kind of interpretation. So why not go consistently with what the Parent Act does with all issues concerning...
There's no Parent Act here.
No, you're talking about Act
29.
29.
Act 29. The criminal jurisprudence. That's what it has stated.
But if it talks about natural carnal knowledge, which has not been mentioned under this present bill,
No.
How do you marry that?
But procreation is, excuse me, is a species of an inchoate offense. It's a species. So it's the same definition that you get for other inchoate offenses. But if we try to widen the cap, say through corrupt means, through false pretenses, what have you, because of the words being imported, which has been imported, that's why we came to that conclusion. But if, in the wisdom of honorable members, we still think that we should go beyond the Parent Act.
It's better.
Honorable Chair,
This rendition is better.
Honorable Chair, this rendition is more superior and appropriate for the purpose of the mission we are trying to cure. We all appreciate that due to the anachronistic nature of some sections in Act 29, that is why this bill has even arisen. And therefore, and having no doubt as to the definition of procuration, this current rendition rather gives various avenues and dimensions within which procuration is deemed. And therefore, I do not think we should change anything in the original rendition. Let's maintain what we have.
You've done well.
Let's maintain what we have.
Yeah, okay. So, any more on 4? Senator, please come.
In 4.1, we have listed the by threat, obstruction, deterrence, improper or corrupt means molestation, intimidation, or inducement, false pretense, or false representation. I propose we add or any other means. Or any other means. A person shall not by A, B, C, D, or any other means.
Yeah, I think so.
Yes.
I think so. So we add a omnibus clause.
Yes.
That will cover other means. That's with technology, there will be some other things that will happen in the future.
Yeah.
Okay. So, or any other means.
Or any other means, technological or otherwise.
No, any other means. Just leave it that way. Any other means, whether it's technology or it's by Nana Drobo Airlines, whatever.
By technology or technological or otherwise.
No, any other means. It covers everything.
It's futuristic.
No, any other means. That's fine.
But these ones look.
We'll cover technology, to cover Nana Drobo, would cover spiritual and everything. Anyway, so that's fine. 4, we are done with 4. And I'm sure it's a good time to. No, we are adding. Or any other.
means. To kill another person.
Or false representation.
You see, if you look at the genus, threat, abstraction, deterrent, molestation, intimidation.
Avant-garde, can you use the microphone?
Inducement. Apologies. Or inducement, intimidation, or inducement, false pretense, or false representation.
Or any other.
Or any other.
Yeah, so in my view, I think that the improper or corrupt means should go. Because then it will be taken care of by any other means.
Yeah, I think so.
Because if we introduce improper or corrupt means, we may have to go and define it. It doesn't belong to the genus, the chain of instances we are looking at here.
Yes, I appreciate where you're coming from. So we can take that off and put the or any other.
What would be an example of improper or corrupt means? You see, we should not be seen to be watering down the bill at all. That impression should not be sent out.
No.
We can only enhance or maintain.
What we are doing is to avoid a situation where it will be difficult for a prosecutor.
Interpretation.
Yes.
Improper. You are not talking
now
about
we are
improper.
looking at implementation.
What is
So
improper?
what would be an example of improper or corrupt means?
The reason we want to
Which
take
we
it
are
off.
struggling to give. That's why it should be deleted.
That's why we want to take it off and
So
put
that any other means, if it happens, any other means.
Let the court determine that other means.
Yes, Chairman.
Dr. Foley.
Yes, Mr. Chairman, quickly. So it is not an addition, and I've just consulted bilaterally with drafting, that what we're seeking to do was just to align. So we can work on the language with her to ensure that at least it's one clause, that this and 107 speak to each other. The other point I forgot to mention was our humble proposal that the punishment, procuration already is a misdemeanor, so that we also align the punishment, yes, with that.
Very well. I
So think
direct
we can work on the
that.
drafting
I direct
details.
that draft persons do the alignment.
Yes.
And then we get
Thank you,
the right rendition. Okay. On that note, we are done with clause 4, and so we can take a break. Sammy, any housekeeping announcement? Sammy, any housekeeping announcement? We are done with clause 4. We have to do lunch and come back.
Thank you, Chairman. Chairman, lunch is ready. Honorable members and other invitees with their coupons will go for lunch. Yes, you should have by now. And then those without their coupons, please stay. We'll bring the packed lunch for you now. Thank you very much.
For the avoidance of doubt.
Those without coupons, please, your lunch will come in here and we'll give it to you.
When?
Now.
Is it okay to leave our staff here?
Yes, we are here.